Hi, Allison. How are you?
Good morning. I'm doing well.
Good morning. So we're live on YouTube and recording right now. So we'll get started in a few minutes. Once we have a quorum, I'll let you know, okay?
Thank you.
Well, good morning. I think you're on mute.
The unmute. Good morning, Don. This is Paul Ware.
Good morning. How are you doing?
Quite well, as in much better than my client.
Yep.
He'll be, just for your information, I'll make this clear to the chair. He will be joining us just by phone. He is bedridden because of COVID.
Okay, so the chair is going to be Vice Chair Allison Schliff today. And it looks like she stepped away from the meeting for a few minutes.
Okay.
Okay, but I've noted that, so he will be joining us then.
Yeah, he's just going to call in. We had a video available at his office, but of course he can't go into the office now, but he'll be calling from his house.
Okay.
Thank you.
All right, yeah, we'll start the meeting in a few minutes once we have a quorum. Good morning, Member Gonzalez. Good morning, Member Gonzalez. Can you hear me? Member Gonzalez, when you have a moment, can we do a mic check to make sure that everyone can hear you? Good morning, Emily.
Good morning, Don. How are you?
I'm doing great. I can hear you perfectly fine too.
Perfect.
We'll get started in a few minutes once we have a quorum.
I hope you enjoyed your time off.
Yeah, I was actually really busy and yeah, I was at a conference the last couple of days, so so it was nice to get away, but it was still work, so
Not as fun as I'd hoped.
yeah. Member Gonzalez, can we do a mic check real quick? I just want to make sure that everybody can hear you.
Yes, good morning, ma'am. Can you hear me?
Yes, good morning. Thank you for joining us.
Thank you.
Good morning, Member Spencer. Good morning, Member Powers.
Good morning.
Good morning.
Good
morning.
morning. Good morning, Heather.
John, would let me know when you'd like me to call the meeting to order. It looks like we have quorum.
Yes, we do.
We're waiting for
Um,
everyone else.
Okay, yep, we can get started. We're broadcasting live on YouTube and this meeting is being recorded.
Good morning, everyone. Welcome to the October 28th, 2021 meeting of the San Diego County Air Pollution Control District Hearing Board. I will now call this meeting to order. Madam Clerk, will you please call the roll?
Yes, thank you, Vice Chair Slick. Before I call the roll, I'd like to note for the record that all members are participating via teleconference, and as such, all votes will be taken by roll call vote. Member Gonzalez,
Here.
Member Powers,
Here.
Member Schlick,
Here.
and Member Spencer.
Here.
Okay, thank you. I will now swear in anyone who would like to speak on an item that is on today's agenda. This includes any members of the public, APCD staff, petitioners, and their representatives. At this time, please turn on your video and raise your right hand if you will be speaking on any item on today's agenda. Okay, so do you solemnly swear that the testimony you give in the matter before this hearing board is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. I would ask that the following individuals now please identify themselves for the record. Hearing Board Counsel.
Emily Helms, Senior Deputy County Counsel, Counsel for the Hearing Board.
Thank you. Air Pollution Control District staff.
William Jacks, Chief of Compliance. You're on
Yeah,
mute.
and you're on mute.
Try again. Dan Plotner, Program Coordinator.
Thank you.
Scott Nestor, Civil Actions Investigator.
Thank you.
Julie Byford, Civil Actions Investigator.
Thank you. Anyone else? Okay.
I
And,
let's
oh,
ask a question real quick.
yes.
There's a member here, or guest Heather McGee Hill. She didn't raise her hand and swear. Is she going to be just observing the meeting, or?
I'm in training, so.
Yes, thank you for pointing that out. I'm here to train.
Okay, thank you.
Okay. Can you please identify yourself for the record, just so that we know all the APCD staff that are on the call?
I'm Civil Investigator Heather McGee Hill, and I'm here to observe as part of my training.
Thank you.
Thank you.
Okay, now I would like to ask that any individuals that are representatives of the petition before us, 4523, please identify yourself for the record.
Good morning. This is Paul Weir. I'm the senior engineer with Atras LLC. and the designated representative for the petitioner, Tom and Jerry Perot.
Okay, and it looks like you said petitioner is joining us by phone, and it looks like we do have them on the line. I'm going to ask them to unmute themselves so that they can also identify themselves for the record. So whoever has, oh, go ahead.
Hi, my name is Gerald Peralt of Tom and Jerry Peralt.
Okay, and I think you joined us after we did the swearing in. So do you solemnly swear that the testimony you're given the matter before this hearing board is the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you for that. So Madam Chair, we can now proceed with the administrative items. Before we do so, I do want to note one thing. I would like to recognize and say congratulations to Member Bill Powers. During the governing board meeting on October 14th, they chose Bill to serve another 3 years on our hearing board as the engineering member. So once again, congratulations to Member Powers.
Congratulations.
Thank you.
And it's just going to be so wonderful to have your expertise continuing to guide the hearing board.
Thank you for those kind words.
Yes, we look forward to working with you in the coming years. Okay, so we can move on, Vice Chair, to the approval of the meeting minutes.
We will now move to the approval of the September 23rd, 2021 San Diego County Air Pollution Control District Hearing Board Statement of Proceedings minutes. Has everyone had a chance to review the minutes? Are there any questions or additions or concerns? Yes, Julie?
Hi, I would just like on the roll call portion where it says petitioners present, it says petitioners present, petition 4521 Tom Rosales for the Assistant Director of the City of San Diego Public Utilities Department. The district is the petitioner, so I would recommend kind of separating us out as petitioner Julie Byford, San Diego Air Pollution Control District and Civil Actions Investigator. Go up a little bit, Dawn.
Yeah, that's right, because the city was the respondent, correct?
Correct. So I would just maybe put petitioner present, Julie Byford, San Diego Air Pollution Control District, and then respondent present, and have that be the city. That's all I had as a suggestion.
Okay.
That's wonderful. That's a wonderful clarification. Thank you so much for bringing that to everyone's attention.
My pleasure. Thanks for allowing the correction.
Were there any other corrections, concerns, or questions about the meeting minutes from Thursday, September 23rd? Okay, seeing none. Is there a motion for approval? And maybe we'll give Dawn a minute to finish the corrections, but.
Yes, I can go back and format these later too.
So, so given the corrections of listing the petitioners as the district and the district representatives and the respondent, that's been corrected now. Is there a motion by member Powers, Gonzalez, or Spencer to approve the minutes from September 23rd?
So moved.
Okay, member Spencer, thank you. Is there a second?
Second.
Member Powers, thank you. Madam Clerk, will you please call the roll?
Okay, thank you, Vice Chair Slick. Member Gonzalez?
Here.
So you have to say yes or no whether you're voting on the meeting, or you can also abstain from voting.
Yes.
So yes, okay. Member Powers?
Yes.
Member Schlick?
Yes.
Member Spencer?
Yes.
Okay, then that passes and the minutes have been approved and they will be posted on the hearing board website after this meeting.
We will now move to the adoption or rejection of the resolution authorizing teleconference public meetings pursuant to Government Code Section 54953, as shown in Attachment A to today's agenda. Has everyone had a chance to review the attached proposed resolution? Dawn, should we put this on the board or just like on the, should we share the screen?
Yes, I can pull this up on the screen here.
Thank you. So there are a number of whereases setting the factual foundation for this resolution. The resolutions being considered is on the second page, numbers 1 through 6. We have the recital set forth above being true and correct and forming the basis for the resolution. We are a legislative body. As a hearing board, we're also a fact-finding body. So, but here we need to decide, do we find that there is an existing proclaimed state of emergency? Number 3 is going to be about the Brown Act requirements. And if anyone has any questions, Emily Helms is present to provide any guidance that we may need on any of these matters. Number 4 is about implementing the resolution. Okay, number 5 is going to apply to any subcommittees. I don't believe we have subcommittees of the hearing board.
No, we do not at this time.
But just in case we did. And number 6, it will take effect immediately upon adoption. So are there any concerns or questions? Any discussion on this agenda item?
Vice Chair, can I just say something real quick? So my understanding is that this would be something that if you were to vote today to continue having these Zoom meetings, that they could continue until January of 2024. So if you vote today to continue the teleconference meeting, then every 30 days after that, you would just need to revisit this and reapprove it. So there would be a separate attachment B that would be presented at the next meeting on November 18th, and then you all would just have to vote on that every month. Also, if we were to return to in-person meetings, we'd be meeting at the County Administration Center, which is downtown San Diego. We do have a room available there, but the meetings would not be broadcast via the internet. They would be voice recorded and then posted on our website. So there would be a change there, and you all would have to go down to the CAC. There would be parking available. So just in case that is a concern. And if you have any questions about that, you can let me know too.
That's very helpful information as to the logistics of our meetings. So this would be at the administration, the county administration. It wouldn't be, for instance, at one of the air pollution control district offices or conference rooms?
No, it would not, because we do not have enough seats or the dais for board members. Here we just have a conference room. So yes, we would all have to go down to the CAC, which is downtown on the waterfront there.
And that makes sense because as some of the whereases explain, the California OSHA standards, right, require distancing still, right, distancing of 6 feet or more, and And maybe before COVID, I don't know, I wasn't on the hearing board before COVID, so I don't know if people were, what was the hearing board meeting in person, maybe at one of the district offices. I'm not sure, but you could crowd more people in back then, right? But we have to spread out for everyone's safety. So just, that's just very good to know. Are there, actually, I think I actually need to ask, is there a motion for approval? And then actually we'll discuss in more depth anything.
Vice Chair Slick, I think that you have to have the discussion before there's a motion for approval, because once it's approved, then the discussion is closed. And Emily Helms, our counsel, can correct me if I'm wrong on that, but that's my understanding.
Okay, yeah, I just wanted to make sure I was going through the right, parliamentary procedure orders, but we can certainly discuss and then I'll entertain a motion. I just wasn't sure if I was jumping the gun on discussing it, so I apologize, but
may I jump in? I just wanted to add one clarification. I just wanted that our findings can't be based on whether or not we should be meeting at the CAC or not, or whether or not it's convenient. Our findings need to be based on whether or not there's the public health emergency. So just that's something to take into consideration.
Yes, of course. I think that's basically what Dawn has provided was just some just additional information. But yes, very good point, Emily. That's not the reason for these details. That's just informational only.
Yes.
What's important here is that we're thinking about the safety and how to conduct these meetings safely and still provide access to the public given the safety issues. So but let me just step aside from talking and see if there's any additional, if there's anyone else, any other members that have observations about this administrative item.
Yeah, I have one question. I mean, it doesn't really have to do with the content of what's in the resolution or the health aspects, but is this something that we should, and I guess this is a question for council, are we required or should we seek public comment on this before voting on it?
Yes, so we would seek public comment on if anyone who is present to comment, they're permitted to comment.
Yes, and this is part of the agenda that's been posted and noted on the public facing website. For the required number of days before this meeting. So are there any members of the public, not just members of the hearing board, but are there any members of the public here that wish to be recognized or speak on this matter?
Vice Chair Schlick, there are no members currently present, no public members currently present that would like to speak on this item.
Thank you.
And one more clarifying point, I think Dawn already touched on this, but this resolution, it would apply for 30 days. So the board would come back in 30 days and we'd need to, should the board decide they'd like to continue meeting via teleconference, they would need to make another resolution at that point. Our recommendation is to adopt the resolution, should the board decide to adopt the resolution, is to do it every meeting, just because sometimes meetings get canceled and we don't want to run afoul of that 30-day window. So that's just a little note on the procedure.
Very good. Thank you for clarifying that. And then we would continue doing that every 30 days, as the situation continues, and if we're still thinking that's the best course of action. And I guess that would be until there was a date mentioned of January 2024.
Yes, the legislation allowing these teleconference meetings, it's essentially a suspension of a few of the Brown Act provisions that will be in effect until January 1st, 2024.
Okay, but we're still providing access to the public through the YouTube, through all the notices, through the access phone numbers, and just to clarify, Ms. Holmes or Dawn, members of the public can Zoom into these meetings as well, right? They don't merely need to call. They could appear virtually, with their facial presence? Or do they call in?
Vice Chair, so my understanding is when they were having these meetings in public, that there is not going to be Zoom or broadcasting capabilities. So anybody that wants to attend the meetings, whether it's members, APCD staff, members of the public, they would either have to attend in person, and I believe there will be an option for them to call in. But Zoom at that point would no longer be an option. And Emily can also clarify this because I'm not sure either. There probably wouldn't, if you voted to not have the Zoom meetings continue after today, the virtual meeting, I believe you would not be able to go back and then start having the Zoom meetings again. So Emily, can you clarify that? Because if they were to vote that they do not want to continue with the virtual meetings, they would not be able to go back and, like, let's say the following month, decide that they want to have the Zoom meetings again, right? It would just continue to be in person at that point.
I don't know that that's a definitive finding. We would probably have to go back and make this this resolution that's proposed to us today. I think we could make that resolution again and then turn back, say if the health crisis got worse. But I would need to do some research, which I'm happy to do.
Yeah, and basically my question was that if we approve this resolution, if we continue, we're even though Ms. Helms mentioned that this allows, some loosening of some of the Brown Act restrictions, but we're still following the whole public access to the meetings. We're, everything that is involved in the purpose of the Brown Act, right, is to provide meaningful public access and transparent governmental body meetings. We're still following all of that essence of the Brown Act.
Correct me if I'm wrong, Vice Chair, but I believe your question was whether should we continue teleconferencing? Can members of the public Zoom in and show their faces? Is that correct?
Yes. Yeah.
Yes. Dawn, can you confirm?
So as I was saying, if we were to go to in-person meetings.
No. If we're staying, if
we're staying virtual. Yes. So members of the public, if we were to stay virtual, we would still continue in the format that we're in right now on Zoom. Members of the public would still be given access. And then also if we were to return to in-person meetings, they would also have access. It just would not be via Zoom. They'd either have to attend in person or they'd be given a number to call in. And again, since it's not going to be on Zoom, we would provide a voice recording versus a video recording of the actual hearing board meeting.
Okay, so I feel like we've had all the factual information presented. I would like to ask, is there a motion to approve?
I'll move again.
Okay. Oh, did you move previously?
Oh, no, I moved on the previous item.
Okay, thank you. Just clarifying. Okay, so yes, so there is a motion now by member Spencer. Do we have a second?
Second.
Member Powers, thank you. Second by member Powers. And this, just to clarify, this is a motion to adopt the resolution?
Yes.
Yes, it is.
Okay, thank you. I'm circling the right things on my worksheet here. Madam Clerk, will you please call the roll in regards to this administrative item?
Yes, so member Gonzalez.
Yes, ma'am.
Okay, member Powers,
Yes.
member Schlick,
Yes.
and member Spencer.
Yes.
Okay, that motion passes with all members present voting aye.
Okay, I believe, yeah, there we go.
Okay, go ahead.
So next on our agenda is public comment. And we did double check and check for any public comment regarding the last administrative item, but also just asking, before we began our administrative items, Madam Clerk, have we received any requests from members of the public that wish to address the board today?
No, Vice Chair Schick, we have not received any requests from the public to make public comment today.
Okay, thank you. Let's see. So being there are no public comment requests, now we will be turning to the petitions before the board. Madam Clerk, can you please introduce our first petition?
Okay, so our first and only petition today is petition 4523. It was filed by Tom and Jerry Peralt, and the petitioners are requesting an interim and regular variance from condition number 13 of certificate of registration number APCD 2019-PTO-003287. And the petitioners seek relief from the annual operational limit for the diesel engine that is located at 3210 Oceanside Boulevard. And they're asking for the variance to continue through December 31st of 2021. The petitioner's business recycles broken slabs of asphalt and concrete into usable base materials. I just wanted to note too for the record that the clerk of the board was notified via telephone late yesterday on October 27th, which is one day before the scheduled meeting today, by petitioner's representative that has joined us today, Paul Weir, and he stated that the petitioner would like to request a continuance for the petition 4523. Now, as part of that, I'm going to read Rule 23 of the Hearing Board Rules and Regulations. I've also included a link for everybody in our chat here to where those Hearing Board Rules and Regulations are located on the APCD Hearing Board webpage, just so that you have them and you know what I'm referencing. So Rule 23 regarding continuances, and you'll have to bear with me because this might take a few minutes, but
John, real quick, John,
ahead.
Could you post that link again in the chat because I do not see it?
Oh, yes, I probably posted it too early. So here, let me just post that.
No, actually, Dawn, is the chat publicly available to all members of the public?
It looks like it's available to whoever is on the call. I don't know if they can see it on YouTube.
No, then let's go ahead and just post any link on the screen itself, because we shouldn't be having chats on the side that aren't available to the public.
Thank you so much. That's a really good point.
Okay, let me open up a Word document here real quick and then post it. So just hold on 1 second and let me do that.
And while Dawn's pulling that up, the general rule is that a continuance may be granted for good cause.
Oh, thank you. And I do also want to say that the Hearing Board Rules and Regulations are one of the links on the Air Pollution Control District's Hearing Board webpage. So if anyone is eager to go there and they don't want to wait for Dawn to put this on there, it is there already for the public. But it's going to be just so great to have it as part of our meeting. So over here on the screen. So thank you, Dawn.
Okay, here is the link here. And if you just go to our Hearing Board webpage, as Vice Chair Slick said, if you scroll down, there is a link that says Hearing Board Rules and Regulations. But here is the direct link if you'd like it.
Okay, great. And I see that link is https://www.sdapcd.org/content/stc/apcd/en/hearing board/rules/apd.html, in case we have any visually impaired viewers.
Yes, and if anybody is unable to access the link, they can also contact me to get that email address or get that website address. But again, this is if you go to our website and you search for the Hearing Board, it is located on the Hearing Board page toward the bottom of the page, all the rules and regulations.
Okay, thank you. And you would like to read the rule, Dawn?
Okay, so I was going to read Rule 23 regarding continuances before you all make your decision on this, and or actually before I open the floor up for discussion. So Rule 23 of the Hearing Board Rules and Regulations regarding continuance states under Section A that the Hearing Board may grant continuances for good cause shown. Except for good cause, all requests for continuances of matters set for hearing shall be in writing. And you know what? Let me see if I can just pull this up real quick so that you can all see it and read along with me. So here's what I'm going to be reading, highlighted in blue. Okay, so let me continue. So except for good cause, all requests for continuances of matters set for hearing shall be in writing and shall be received by the clerk of the hearing board at least 3 business days prior to the time set for the hearing. As soon as the moving party discovers or reasonably should have discovered the event or occurrence which establishes good cause. Requests for continuance shall be made only after the requesting party has contacted the other party to discuss the continuance. The written request for continuance shall state when the other party was contacted to discuss the continuance, and it shall state whether the other party opposes or has no objection to the request for continuance. Requests for continuance made orally at the time the matter is set for hearing before the hearing board are discouraged and will not be entertained unless the requesting party has discussed the request for continuance with the other party prior to the commencement of the hearing. In considering whether to grant a continuance for good cause, after 3 business days have lapsed, the hearing board will consider whether the party seeking the continuance is not responsible for and has made a good faith effort to prevent the condition or event establishing good cause. Section B states that the hearing board may find that good cause exists if it finds that the matter before the hearing board involved issues which could not be adequately addressed through the filing of the petition and additional memoranda, and in the time permitted under these rules and regulations, or if the hearing board determines that additional time is necessary or desirable to determine the issues or to receive additional evidence or legal argument. If a continuance is granted pursuant to this subsection B, the hearing board may adopt a schedule according to which the parties shall file and serve any additional materials.
Thank you, Dawn. Now, would we have the petitioners speak to their request for continuance and whether there's good cause? Because it sounded like the first option is we may grant continuances for good cause, and if there is good cause, we don't need to consider the 3 days or the in writing, because it sounded like you said they requested the continuance 24 hours prior by phone. So I would just like to ask the petitioners to speak on what good cause exists for your continuance request.
Thank you, Madam Vice Chair. This is Paul Ware.
Thank you, Paul.
The petitioner's general manager, Jerry Peralt, was diagnosed with COVID last week, has not been able to return to work, and in fact is at home. And at that time yesterday, when I was confirming that he could actually attend this hearing by video conference, we had planned to have it at his office. His symptoms were such that he was just experiencing a lot of tiredness. So as a matter of prudence, then I notified the clerk of the board as well as a district representative that if questions were to come up for Jerry Peralt, he might not be able to answer them. I spoke with Jerry this morning, and I believe he's still on the line. But if there's going to be a lot of details about the operation of the facility, you'll just have to bear with him and see if he can actually respond to those. I'm good for all the technical aspects of how health risk assessments work and how engineering conditions work. But again, that request then was not knowing for sure if Jerry would be able to, so to speak, answer the bell this morning. And perhaps you could inquire if he's still on the line.
Yes, Jerry, are you still on the line?
I am.
And I just want to wish you that you get better soon, and that you can fight this illness. We're all sending our get well wishes.
Thank you. Thank you.
Yeah.
So, Madam Vice Chair,
Yes.
then I think unless we run into a situation where researching records at his office would be necessary to answer a question, I believe at this time we could proceed with the hearing. And unless we run into a situation where a continuance, then I think it would become obvious if there's something that we just can't address today. But other than that, then thank you for your patience, and I am prepared to go forward.
Okay, so the request for the continuance, it appears has been withdrawn basically, and we will we'll go ahead and proceed then with the petition, the consideration of the petition.
Okay, Madam Vice Chair, before we do that, the clerk of the board has also received a presentation from the district yesterday on October 27th, around later in the day, around 5 o'clock. And so in order for these documents to be accepted as part of the hearing, it requires a majority vote of the board in accordance with Rule 31 of the Hearing Board Rules and Procedures. I'll read Rule 31, but just so you know, the presentation, it is a PowerPoint presentation from the district. And this is something that you have not seen. As you're aware, just so you know, the district, they turned in their response. There was a response back from petitioner that we received 7 days before the meeting. So that was shared with everybody. And then now, in addition to that, the board is being asked to consider an additional presentation from the district today. So per Rule 31 of the Hearing Board Rules and Regulations, I'm just going to read this real quick. An applicant, district, or member of the public, except for emergency variances, has 7 days prior to the hearing board meeting to supply written information to the clerk of the board. And if the written material is not submitted by the 7-day deadline, the Air Pollution Control Hearing Board will not consider the written material, and it may not be entertained unless good cause is shown and approved by the majority of the board.
Okay, so I would like to ask someone from the district who will be presenting this PowerPoint, if this is approved, what is the good cause for accepting this material?
Hi, this is Scott Nestor. I'm a civil actions investigator for the district. This is it's a PowerPoint presentation. I think it would communicate our position very clearly.
Okay, so the good cause being that it would be helpful to the board. I guess what I'm wondering is, what's the good cause that it wasn't submitted 7 days before? If you could just spell that out.
Yeah, good question. The petitioner submitted an additional information on the 21st, which was 7 days. We could not put together a response and our full position in a presentation at that point.
Okay, so is there a motion from any of the hearing board members to accept these materials to find good cause?
Madam Chair, Madam Vice Chair.
Oh, actually, yes. Yeah, does petitioner have any comments on this?
Yes, normally, if we'd had a chance to review that information, we would, of course, accept the district submittal for that. However, I just checked my email a second ago. I believe the district has chosen not to share that information with myself or the petitioner. If I am incorrect, I will stand corrected. But given the history of this happening, I can remember at least one other petition where this occurred, and we were not served with that answer or additional information. Then I believe in all fairness, we would then ask for the continuance so we could review this. I just don't understand, unless I'm incorrect and it was actually emailed to me either yesterday or this morning, why the district would proceed in this way and expect that we wouldn't ask for a continuance to be able to review this.
Okay, so let me see if I understand. So your concern is that even though the district is asking for good cause, that they should have had at least sent you their PowerPoint as soon as they had prepared it and gotten it ready, if that was yesterday or even this morning. So any member of the district wish to speak to that? Yes, Dan Plotner.
Yeah, thank you, Madam Vice Chair. Dan Plotner, Program Coordinator with the district. The PowerPoint presentation is an aid to the oral presentation that Scott Nestor will be giving today. So it's not part of the position paper that would typically be included with an advance written response. So this is no different than giving an oral presentation, which we would not send in advance to the petitioner or to the board. This is merely an aid to something that Scott will be saying today.
Okay, I guess I need to ask Ms. Helms, could you provide now I'm very wishing some guidance, please, because Dawn, our Madam Clerk, had said we needed to kind of find good cause to accept these materials. But then if it's not really materials, it's just an aid, then it's almost sounding like the district is saying this is not something that had to be served on the petitioner. So now I'm a little bit confused.
So there is no requirement under Rule 31. Well, let me pull that up again. No, so if the board finds good cause, there's no requirement to share with the petitioner prior to the hearing. It's typically, I mean, I believe the parties often do that, but that's not required for the board to find good cause.
And if I may add, Vice Chair Schlake, apologize. William Jacks, Chief of Compliance. Typically each petitioner and respondent has the opportunity to make their case, to present. And so it can be in a different format. It's going to be a matter of where we speak and you hear what we're saying or actually have something viewable. The petitioner has that opportunity to do that as well. And so in this case, we have provided an additional PowerPoint, just go along with the talking points to help convey our understanding of the petition.
Well, let me ask any of the members of the district that are here representing the district. So are you saying that that petitioner could additionally present a PowerPoint without having shown the PowerPoint to you today?
That's correct. It's up to you, to your board, to make a decision if you want to accept it, though.
Yeah,
and that has happened historically throughout the years.
Okay, so similarly, the petitioner has the same privilege to, if we were to find good cause on their behalf, they could have a PowerPoint as well.
Yes.
Okay.
If I might add, the hearing board isn't bound by traditional rules of evidence. So, well, if you were involved in, I don't know, a formal hearing before a court, that might be required. Here, the board is encouraged to take information that it believes would be helpful. And if it's the kind of information reasonable people would rely on in serious matters.
Yeah, I just kind of wanted to make sure that it was equally fair for either party. Okay, so is there, so I believe my questions have been answered. Are any other members of the hearing board have questions, concerns, or a motion to accept the district's PowerPoint as an aid? And they are arguing they have good cause because of the response received on the 21st.
I would make a motion to accept that with one caveat that there's no new substantive information in the presentation, that it's simply an aid.
Great. Okay, so we have a motion on the table from Member Powers to accept the PowerPoint of the district, subject to the condition that that there's no new material new compared to any of the district's previously submitted written materials. Okay, do we have a second?
Second.
Okay, thank you, Member Spencer. We have a second. Madam Clerk, would you call the roll?
Thank you, Vice Chair Schlick. Member Gonzalez,
I vote yes, ma'am.
Member Powers,
Yes.
Member Schlick,
Yes.
Member Spencer.
Yes.
Okay, that vote passes with all members present voting aye. So I do have the PowerPoint presentation here, and I'm not sure, do you want me to show the presentation now or when Scott Nestor presents it? I'm not sure what you want to, how you want to proceed with this, Member Schlick.
So do we normally have the petitioner present their request first? And then we have the district present, or?
Vice Chair Schlick, historically, it's been the district first. Whoever petitions goes second, but I don't know, Emily, if that is actually in the bylaws itself, but that's how it has been done historically in the 6 years I've been involved.
The rules provide that the district provides first, but the chair is able to alter that. So, so should you decide that you would prefer the petitioner to present first, you may proceed.
Let's go ahead. Yes.
Madam Vice Chair.
Yes, I recognize Paul Weir.
Thank you. The hearing board rules provide for the district to provide a short summary of the nature of the petition, and then the petitioner to go forward, present his case, and the district then to present their final case. So to the extent that the district is just prepared to summarize but not testify regarding their positions, that's acceptable to us. However, again, my concern might be that the PowerPoint presentation. Yes, thank you.
Yeah, so it looks like you're talking about Rule 18. So
Yes.
Thank you for bringing that to our attention. So let's go ahead and just follow the book. So here I would invite the district to provide a summary of their evidence. Okay, then we'll hear from the moving party, the petitioner, and then the district will have a chance to respond. Then we'll take any public testimony, and then if necessary, the petitioner could have any rebuttal evidence or argument as in the district as well. Okay, thank you.
Thank you, Vice Chair, and that's exactly how we would like to proceed then. Thank you.
Yes, so yes, I invite the district to proceed with their summary.
Okay, it would be easier if we could go through the first few slides of the presentation, and I'll stop before
I. Yeah, that could definitely be part of your summary. That's fine.
Okay. All right, thank you. Don, could you pull up slide 1, please?
Yes. Can
Okay.
everyone see the screen? Okay.
So this is just for this opening statement, I'm just going to be covering the first, I think, 6 slides. Okay, let's go on to the next slide. That's a little background on the operation itself. The petitioner, Tom and Jerry Peralt, operates a relocatable, recycled asphalt and concrete crushing plant that is authorized to operate in Oceanside and Fallbrook. The plant consists of a crusher, a 2-deck screen, a stacker, and conveyors, and they're all powered by a 388 horsepower diesel engine. The engine is limited to 1,092 hours per year at the Oceanside site and 1,408 hours per year at Fallbrook, and 8 hours per day at both sites. It commenced operation in May 2019, and based on petitioner statements, we understand that this is a small business. Next slide, please, Don. Here's some photos so you can get an idea of the operation. On the left, you can see the feedstock, which are pretty sizable chunks of concrete. Those are loaded into the McCloskey crusher, the picture in the middle, and the crusher crushes them up into a fine fill material that's applied on site, or could be applied anywhere, actually. I don't know if you can see that the picture on the right, but it shows the stockpile to the right of the stacker. The stacker is that yellow device with a conveyor belt on it. The stockpile, if you cannot see it like I can't, it looks to be 15 to 20 feet tall. That's what the operation kind of looks like that we're talking about. The engine is inside the McCloskey crusher, the 388 horsepower diesel engine. Okay, next slide. This is a bird's eye view of the area. You can see the plant is the blue point adjacent to the sports complex in Oceanside. It's about 2,000 feet from the nearest school, which is in the upper right corner. And you can also see that there are residences to the north and east of the, actually that right there. Those are the closest residences, as well as the new residences over on the east side to the right of the plant. Yeah. Okay, so the next slide, slide 5. APCD inspected the Oceanside plant in June 2020 and found that the engine had already operated over 800 hours that year. So it was clear that the annual hour limit could be exceeded in 2020. And our inspector informed the facility personnel of this potential. The next time we inspected was in September 2021, last month. At that time, we found that the engine had indeed exceeded the hour limit in 2020, and it did so again in 2021. So we issued the notice of violation for exceeding the annual hour limit in the permit. Next slide, please. So the variance petition is seeking relief from that annual hour limit for the Oceanside operation from now until the end of the year. The petitioner clarified in their October 21st memo that they are not seeking relief from the 8-hour daily limit, and we do appreciate that clarification. Petitioner claims that if no relief is granted, they would essentially need to shut down their Oceanside operation, and they would suffer revenue and employment impacts until the end of the year. If the variance is granted, petitioner proposes to lower their daily limit on material production during the variance period and also accept a fuel use limit on the engine. They also committed to submit a permit application, which they did on October 13, and to monitor and report their use of the engine during the variance period. So that concludes my opening statement.
Okay, thank you. So that seems to be a summary of kind of the factual situation. Do you have a quick summary of why the district is opposing this, or should we wait for that after the petitioner?
If I may interject, yes, again, apologize. Yes, I think if we're allowed to continue with the presentation, I think our position would be clear. So my suggestion, I think we were on six of, I think, 9. I think if we continue, that'll be clear, if that's okay with you, Scott, and the board.
Yeah, because I believe the summary can include what you're summarizing is your case. Okay.
Thank you.
And Madam Vice Chair,
Yes, Paul?
on behalf of the petitioner, the first 6 pages were precise and exactly what we had hoped that the district would be presenting as the factual basis for this.
Wonderful.
My only concern, and I would have never objected to 1 through 6 if I had seen them yesterday or even this morning. What I might be concerned about is what the future holds for 7, 8, and 9 without knowing what was going to be presented. But certainly 1 through 6 are exactly what we would have expected the district to present as far as the facts of the case. And so
Okay.
perhaps you could just delay 7, 8, and 9, or
well,
your
and
choice, ma'am.
the PowerPoint is only being allowed to the extent it does not vary from whatever the district has provided you already. So if any party notices that the PowerPoint slides 7, 8, and 9 vary from what the district did provide you in their response materials, that please bring it to our attention and we'll take a look.
Very fine, Madam Chair. If the district could proceed, that would be acceptable to the petitioner.
Well, Madam Chair, there is kind of an issue here because there are some things that we're addressing from petitioner's 1021 memo that have not been seen before. We haven't had a chance to discuss these with anybody yet. This is the forum for that.
Okay.
This is our opportunity to present our position, and so we're requesting, as typical, to continue to do so. Because so far you've heard history, and so I think we need to have the opportunity to, and then again, as per the bylaws, the petitioner can comment after that.
And I need to be able to address the 1021 memo.
Yes.
Yes, Emily, thank you. Thank you. I see your hand.
Yes, so the board's previous motion was to accept the materials, subject to the provision that they would not be considered as far as introducing new materials. In that case, one way forward might be to allow the petitioner or allow the district to present to rebut any positions from the, I think, 1021 memo orally. Otherwise, we would probably need a new motion from the board to accept the materials as they are.
I believe that's very good guidance. Thank you, Ms. Helms. Yes, so the district, in order to state your position, do you think you can provide us an oral summary at this point, and perhaps later, after the petitioner presents their point of view, if you would like to provide the PowerPoints as an aid as well, we can take a look at that and expand the earlier motion to include other material for rebutting what the petitioner will bring up.
One final
Sure.
oh, sorry.
Well,
One final interjection is that the vice chair, Schlick, you may proceed with the order as you so choose. The order of proceedings can be altered by the chair. So whatever you decide is the best way forward, please feel free.
Well, it seems like it would be efficient to continue to hear from the district at this point, because I still don't really have a summary of what of why they're opposing the petition. So so I would like you to continue, and I think that should be good. Thank you.
Okay, then I'm going to continue. Can we go to slide 7 now, Don? Okay, so now we're taking a look at the statutory context for this hearing and the decision. According to state law, the hearing board can grant an interim variance for good cause. For the regular variance, your board would need to make all 6 of the findings. And for the district's position on interim variances, we assess whether the petitioner is likely to make a persuasive case when the regular variance is held. In other words, we use the 6 findings for the interim variance too. Next slide, please. We're going to take a closer look at these 6 findings. For finding A, the district agrees that the petitioner is or will be in violation. And finding B, that compliance is beyond reasonable control and would be an unreasonable taking. We believe that compliance was well within petitioner's reasonable control. We warned them that they could violate their permit in June 2020, and they waited until they got a notice of violation in 2021 to take care of it. We also believe that their reasoning for business closure is incomplete without more explanation of why the Fallbrook site is not an option. Importantly, though, we believe that petitioners' assumption that they'd need to close their operation is an overreaction. For this kind of violation, the district typically issues a notice of violation and then works with the operator on a monetary settlement to deter future violations. I should also note that the engine hour clock is going to restart on January 1, 2022, at which time the variance would not be necessary. Okay, slide 9, please. For finding C, regarding emission reductions, we believe petitioner's statement on excess emissions is incorrect. We maintain that all emissions generated after the engine reached its limit this year are excess, and all excess emissions are significant. In our answer to the petition, we showed that there would be corresponding emission reductions if they complied with their permit. For finding D, curtailment, we understand that petitioner has proposed lowering the production limits, but there's not enough information to conclude that it would actually change their operations. Slide 10, please. Finding E asks if petitioner will reduce emissions to the maximum extent feasible. We believe that petitioner's proposal to reduce their daily production limit will not reduce their actual emissions, since their actual production has been 53% and 37% under the proposed limits as shown on the slide. The second main point here is that petitioner's latest proposal for a fuel limit that's in their 1021 memo would allow much more fuel than it appears that they need based on their operation in the first 9 months of 2021. Here's our math supporting this. They used an average of 53 gallons per day and operated on 61% of the days to date in 2021. And multiplying those values by the 65 days left in the year, the expected fuel use would be around 2,100 gallons, but they asked for 6,100 gallons. So we think the petitioner needs to explain why they're proposing such a high fuel limit. In sum, for finding E, we don't see that their plan as reducing emissions to the maximum extent feasible. On finding F, we believe that the 8-hour per day engine limit is important for reducing the potential for an air quality nuisance. So next slide, please. This is the last slide. So in conclusion, the district opposes granting the variance because good cause was not shown. First, the violation was foreseeable, compliance was achievable, and amending the permit could have been done long ago. Second, the enforcement consequence of non-compliance are not as severe as what petitioner assumed. Findings based on business closure are not realistic. Third, excess emissions would not be reduced to the maximum extent feasible. So we believe the findings cannot be confirmed now, and that will not change before the hearing on November 18th. So this concludes the district's presentation. Thank you.
Thank you. Now I have a clear view of the district's position and summary. So thank you for that summary. And now I would like to invite the petitioner to present their petition.
Thank you, Madam Vice Chair. I believe the clerk of the board could bring up the actual 2-page summary of supported findings. And we could go down there and down those and then augment them with any additional testimony that I believe would be needed to clarify what we have in writing. I know that the hearing board members have that 2-page summary in their packet, but if that could be posted.
Yeah, so Dawn, I believe the petitioner, Paul Weir, on behalf of the petitioner, is asking for us to share the screen of the attachment 2 summary of actions by petitioner. I think that's what he's talking about. I have that, but yeah, okay, great. And I believe it's attachment 2 to their petition.
So are you talking about the documents that were submitted on October 21st?
No, let's see. Actually, I was referring to the facts and supportive findings that was submitted with the original petition.
Oh, okay. What the petitioner submitted. All right.
Right. And in fact, most of what we'll need is in that document that I see flashing before my eyes there. Thank you.
Yes. Okay. So just tell me when you would like me to stop here.
Very good. We're on that correct page right there.
This one. Okay.
So briefly, I think that with respect to finding 1, and the focus right now is going to be first to present a general picture of what's going on out there. And we pretty much agree with what the district has summarized. And then look specifically at the findings that we've proposed for the regular variance and answer any questions that hearing board members may have based on issues that the district has raised. So that'll be the way for me to proceed. Unless the hearing board has any questions, and then just please interrupt me at any time. Okay. So the first one is whether or not we'll be in violation of permit condition 13, and specifically just the engine annual hours of operation. There seemed to be some confusion in the district's first presentation, perhaps clarified recently, that we were seeking to get relief from the 8 hours a day of operation. And that's simply not the case. The way the plant operates is the engine has to start up first, it warms up, and of course, runs through whatever operations of the day, being limited to, again, 6 hours of maximum operation of the plant at 1,500 tons a day. And then the engine will idle back down at the end of a day or during the lunch period while the plant clears itself. So that's the reason why hours of engine operation are different than the hours of plant operation. And as a permit condition, again, we're only allowed 6 hours of plant at 250 ton an hour, but we had initially requested that 8 hours of engine operation. So this is how this plant runs, and it's in balance. And what has occurred, though, is that oftentimes the engine will sit at idle for a considerable number of minutes or hours while it's not polluting at its maximum amount. And that has resulted in more hours during the year than were initially anticipated for this facility. We're not able to move to the Fallbrook facility. COVID restrictions say that that site will actually not be operable, cannot be placed in operation. And indeed, it's difficult to even get the transportation involved to move this to another site. If indeed we had another site or a third site where materials could be dropped off. So that's really where we find the petitioner, limited operation of this small business. And as we go through the rest of the findings, then I believe we'll be able to show that hourly annual limitation, that limitation on annual hours of operation then is actually based to limit the amount of pollution coming out. And we'll be able to show again why operation with a fuel limit keeps that pollution below the levels that the district assumed in their evaluations. So with respect to finding B there, it is true there are 11 people, 7 in operation, 4 in administration, and it is certainly our preference to seek that variance rather than go forward and just operate the engine in out of compliance with the annual hours of operation contained in permit condition 13. If the board has any questions about how Jerry would run his operations if a variance was denied, I think Jerry could answer some of those, but certainly our preference is to have the variance granted, proceed with this. We have an application before the Air District now to modify this condition, so it won't be an hourly condition, annual hours. It will be a condition limiting the annual fuel. With respect to finding C, we don't agree with the Air District that there will be excess emissions. The excess emissions don't occur with hours of operation. They occur with fuel use or production through the facility, however many tons we produce during the year. And that's the basis on which the district limited things, but they chose an imperfect surrogate for limiting those diesel particulate emissions from the engine. the district, in doing its evaluation, and took the maximum amount of fuel per hour times the number of hours times those emission factors and determined what the actual maximum emissions should be. And they properly limited the operation of the facility based on those maximum impacts. What no one considered at the time was what happens when the engine is sitting there not operating at maximum load or even way below maximum load while it's idling, and those additional hours that are not causing the pollution then are accumulated against the annual. So there's the calculations, and later on we'll find this table that I've produced showing that the annual emissions with a fuel limit will be less than what the district assumed for the annual emissions with the hourly limit. More technical argument there. So if the hearing board members would have any questions there before I move on to D, that might be a good time to pause and catch any questions.
Go ahead.
Mr. Weir, I do have a question. Would you say that a hourly operating limit in this case is actually more protective, given that you've got a lot of time that you're at idle, than it would be based on full fuel operation at each hour?
Yes, the annual limit on operations, which is the only part of this that we're trying to address. The daily operations should remain at 8 hours a day. That's a good cap for that. But the annual operating hours, that limitation doesn't really capture the emissions that are associated with annual operation.
Well, maybe I should rephrase this. This engine spends a lot of time not at full fuel operation. It spends a lot of time at idle or something like that. And so what that means is that the actual de facto op of this site under an hour limit is significantly less than the assumption for modeling purposes that the engine is operating at full fire when it is operating.
That's precisely correct, and a great summary of why we believe during the period of the variance we should have this fuel limitation.
Well, let me say this both for you and for the board. I take a somewhat different view because actual operations have a significantly less ambient air impact than the modeling assumption. So if we go to a modeling assumption in terms of how we approach this system, we're actually going to let this system potentially emit, actually, not modeling, but actually emit significantly more than it does.
I believe that's actually incorrect, Member Powers. The assumption on an annual basis was maximum fuel consumption per hour times the number of hours a year that the district has placed in that limit for the site. When the calculations are based on an annual fuel consumption, those emissions will be significantly less than what would be allowed under the 1,000 hours plus.
And I don't dispute this. You are correct. What I'm saying is the actual operation of the engine, actual practice by the facility is X. We're also talking about Y, where we're operating, assuming it's operating at maximum fuel flow during those hours. I'm not trying to be cute. What I'm saying is we have people that live near that facility. They're currently exposed to X amount of emissions because the engine operates variably, it operates at idle It operates at somewhere between idle. So the actual operations of the engine under this hour limit are what they are, which is significantly less than they would be if this engine were operating at full fire during those hours. So what I'm talking about here is the hourly limit in its currently configuration is resulting in X amount of actual emissions. If we assume that this engine, we base our assumptions on the engine always operating at full fire, that does not reflect reality. And I'm not making a decision here, and I'm not trying to be contentious with you. I want the board to understand that its actual operating mode is what counts. And will what we consider today change that and make the permit less restrictive, period.
Yeah, and just to clarify, the impacts from this plant's operation were evaluated by the district as if the engine operated and burned that maximum amount of fuel possibility.
Understood.
And those were found, we had initially requested 2,000 hours of operation, and the district had to, based on health risk assessments, cut that back to slightly more than 1,000 hours at this facility. What has occurred is that we know the fuel consumption and therefore the actual emissions so far this year are well below that impact that was evaluated as being safe for the operation of the plant. And we're simply seeking to find a condition in the variance that would limit that fuel so that we would not approach what was approved as far as an offsite impact. So
that is understood.
Yeah, and Member Powers, you were, I think I misheard your opening, but you were precisely correct in how those calculations should be performed. And what we're going to try and again show is that the operations under the variance on an annual basis, which is the health risk assessment part of it, are going to be much less than what the district has approved in their health risk assessment evaluation.
If I make a quick point, this is not a permit appeal. The arguments being brought here would be relatable if the permit was issued within 30 days ago and this is a permit appeal. The permit was accepted quite a while ago. So the steps for the petitioner is to submit an application so it can be properly evaluated by our engineering division. And basically it's been discussed in the past that the board should not potentially be making decisions that our engineering evaluation would substitute. Again, this was possibly, it could have been submitted a year ago and this was just submitted last week. So discussions, of course, I'm not trying to limit discussions on this, but just mention that, the scope of this is to determine if good cause, if the findings can be met.
And I thank you for that clarification, but this isn't really to me about the permit. It's about making sure that the board understands that there is an emissions impact.
Well, I agree with you.
That's all. And
I absolutely agree what you're saying. I just would make it, in addition to what you're saying, I wanted to just clarify.
And since we're just one final clarification, which I didn't see in the paperwork, is we're concentrating on Oceanside. I get that. The claim by the petitioner is that they don't operate at Fallbrook. Has the petitioner provided monthly, hourly use data out at Fallbrook? I mean, the claim is that COVID stopped us at Fallbrook. So do we see 100 hours a month at Fallbrook through January to March 2020, and then there's no activity at Fallbrook and there hasn't been for 18 months? Is that in the record somewhere?
Member Powers and the board, that would be our testimony that there has been no operation at Fallbrook in 2020 or 2021.
Thank you. No further questions.
With respect to finding D then, which is no longer up on the. Thank you, Don. We believe we do have the answer to how we will correct this so this doesn't become a long-term problem. We have filed that application. And so some of this was written before the application was filed. That application and fees are on file with the district. And it would be my testimony that the evaluation of that application will result in a permit condition being issued that we can live with on the annual fuel consumption. And that if that application is approved, then the variance can be terminated at that time. There will be no need to run that variance further. And so if the district should evaluate it and find out that a fuel consumption limit other than what we're proposing is appropriate, then again, the petitioner and the applicant will accept that, and that variance can terminate at that time. If we could move to finding E. If we look at excess emissions as causing additional offsite impacts other than what was evaluated in the permit, then we find that we can reduce its average allowable daily production and also commit to staying well below the authorized annual production. In addition, we further in our update in response to the district, we've proposed limits even lower than we first proposed here in the petition. And finally, we would note that under F, we have over the years continued to operate without any nuisance violations causing any imminent threat or hazard to public health or safety. We will keep those logs of production. I believe the district has already identified when they would like to see them reported, and we can certainly abide with those. And in addition, something that we feel is going to, I guess in quotes, keep our feet to the fire, we would also propose that a condition be imposed saying we'll work with that APCD engineer processing this so that if there are any further questions that the district has in pursuing this, which is ultimately the answer, so we'll never be in this situation again, we'll promptly respond to the APCD engineer. So far, the district has not had any questions that we needed to answer about that, but that remains a possibility. So I believe that that should be as part of the conditions of the variance. That's essentially our presentation on why we believe that this hearing board in processing the interim variance can find good cause existing, and that we're also confident based on the facts and supportive findings that we would also prevail at the regular variance hearing, which is now scheduled for mid-November. We can move down to those actual conditions that we first proposed. And that would be an attachment 2. Thank you, Madam Clerk. And just one more page. Oh, I'm so sorry. Probably another page there. It's here. Yes, thank you. So these are the conditions that we believe would limit the impacts for the facility. And in parentheses, we tried to show what those limitations would be. Now, again, further on in our presentation with the new filing, the updated filing, these conditions have been further reduced based on comments that the Air District gave us. And those conditions, if we could skip to that last page, then in our presentation, right, no, actually well past the district's response. So this would be our update. Just please keep going.
So you're wanting me to post what was submitted on October 21st, right?
Yes.
Oh, okay, let me stop sharing this because this was posted before that happened. So let me stop sharing and then I will pull up that additional document.
Okay, thank you very much.
Mm-hmm.
Madam Chair, while she's doing that, I want to thank staff there for being able to do it this way. Normally, we would be referring to attachment 1 or 2, and I'd be sitting there or standing there at the podium making the presentation. This is actually, I think, a very effective way of doing it, but I realize that that's putting a lot of burden on the clerk.
Oh, no worries. Is this the document that you were referring
It
to?
is. And then if we could go to that second page and just keep going. There we go. And we're going to get to the conditions. There, fine. And so actually, these would be the conditions that we believe should govern the variance now. So we're going to, in order, we're going to limit that daily operation to 1,000 tons a day compared to what's allowed under 1,500 tons a day allowed by the permit. We're going to average that daily production over the entire period of the variance, so it would not exceed 750 tons a day. That's 50% of the allowable under the permit. We would limit our production during the period of the variance to 50 days of operation and a total of 40,000 tons of production. We would further limit the total fuel consumed. Initially, we proposed 20,000 gallons for the year. Now we're able, by looking at this and recognizing that there will be rain days where the facility cannot operate, we'll be at 15,000 gallons of fuel for the year. We will keep those daily records of hours and fuel usage, as well as daily production, submit those weekly reports. And then I believe the last 3 conditions just make sure that, again, this variance, if granted, make sure that we're covering all other things, all other relevant things, not seeking to exceed any other permit condition, providing that written progress report to the clerk 2 weeks before the date of the regular variance hearing. We could also commit to meeting at least once with the district staff to make sure that perhaps we could even find suitable conditions that the district would be more in favor for if the regular variance was granted. With with the understanding that I'm available for any other questions, and I believe the owner, Jerry Peralt, is as well. That really finishes up my presentation, unless we want to delve really deep into those technical calculations, which I'd be prepared to walk the hearing board through.
I do have a question.
Member Powers, you're recognized by the chair.
Thank you. This is for the owner of the facility, Jerry. So the inspector from the APCD came out in June of 2020. The inspector projected that your hours of operation at Oceanside would exceed your permit limit, and nothing happened. And then we're now in the same position in 2021. So what decision-making process did you go through in June of 2020 when you were advised by the inspector that if you kept up at this rate, you would exceed your permit limit?
I don't remember seeing a air pollution control district inspector in 2020. I just don't remember talking to anybody.
Well, then let me direct the next question to the APCD. Was there an inspector on site in June of 2020? Did they write a report of their visit? I mean, is that it in your records?
Scott Nestor with APCD staff. Yes, we have the inspection report from 2020.
Thank you.
Okay, and I just have a quick question or just a point of information. Mr. Weir, could you just confirm, so this document that was submitted on the 21st of October, we're looking at 3 pages of it. It's out of 60, as you can see on the screen, but the rest of it is just duplicates, correct?
Oh my goodness, I'm not.
I identified this ahead of time and asked the clerk of the board to confirm. I suppose you had nicely provided enough duplicates for everyone on the board to have a copy if we were meeting in person. And so the staff at the APCD office scanned it all. So just if you could just confirm what you intended was just a 3.
Oh my goodness, yeah. Just one of any one of those documents. I didn't realize that they all had appeared there.
Yeah.
I just stopped with my signature page there.
Yeah, just to make it clear that we're not putting the district through 60 pages of having to respond to 7 days before the hearing.
Right, and they are all the same. I had no idea that had happened.
Okay.
We just met. Our goal was, because it was so close to being the time to mail out, we didn't want to burden the clerk of the board with having to make the 15 copies. And there's a provision in your rules of the hearing board that we were to provide that. So we did, but indeed, those are totally duplicative.
Thank you so much. That I just wanted to make that clear for the record. Okay, so if I understand, unless the members have any more further questions for you, you are completing your argument at this time. Oh, Spencer, I recognize you.
Thank you. Thank you for your testimony, sir, and for presenting the position. The thing that I keep coming back to is in point B, that due to conditions beyond the reasonable control of the petitioner. The thing that keeps nagging at me, and I don't think I've heard an answer for, so if you could please provide some additional information, is why is the Fallbrook facility not an option because of COVID-19? In other words, why would it not be possible for you to move the operation to Fallbrook for 6 months and then stay in compliance with the permit? That's what I'm having. That's what I'd like some more information.
Okay, thank you. And I believe there are 3 main points. 1, the Fallbrook facility is closed and not able to receive any materials. 2, it would take time to get there or to some alternate facility that we're not allowed to operate. And three, it would also take time to put materials there for them to be processed through the plant. So fall brick for 2020 and 2021 does not remain as an option under any circumstances.
Thank you for your answer. Member Spencer, do you have any further questions?
No, I don't. Thank you.
Member Gonzalez or Member Powers, any other further questions for petitioner?
Not for the petitioner.
Ma'am, I don't have any questions either. Thank you.
Okay, then at this time, I would like to turn to the district for their response. But if could we take a 5-minute break? I could really use a facility check. Could we take a 5-minute break?
I second that motion.
Okay, let's take a 5-minute break. We would like to be back at how about 10:45?
Very good.
Thank you.
Hey, hi, this is Paul Weir, and I've been participating this morning in a hearing board meeting, virtual hearing board meeting. It will
Thank you. Welcome back. It is now 10:45. Reconvening the meeting and ending the 5-minute break. I'd like to welcome everyone back. We have completed petitioners sharing. We've also completed the district summary, and now we are ready to turn to the district's response to petitioners' testimony and presentation.
For the record, Scott Nestor with APCD. I think one of the things that we are very concerned with is the finding about reasonable control. We believe that it was very well within the control of the petitioner to take care of this problem over a year ago. I mean, we warned them. Even if they don't remember that we warned them, the limit and their hours of operation are in their records, so they could check their permit, they could check their own operational records to see that they were getting close to that 1,092 hour limit in 2020. So we think they had plenty of time to take care of this problem. So we don't think that finding can be made. The other thing is, I think Member Powers really highlighted it, is the difference between potential emissions and actual emissions. The petitioner's argument is really based on an analysis of potential emissions, and that's fine for the initial permitting and for setting those permit conditions initially. But the fact is they exceeded the limit that was set, that they had agreed to, and it's going to be the community that has to put up with the actual emissions that continue from that facility in Oceanside. And I think William Jacks had some additional.
Thank you, Scott. Again, William Jacks, I'm Chief of Compliance here at the district. The petitioners also, as I mentioned before, is providing an alternate permit condition without proper district engineering review, and is requesting for the hearing board to make an engineering evaluation termination, within this period of time, which I think is unreasonable. And again, I think this was brought to the petitioner's attention June of 2020. They exceeded it at 2020 and again 2021. As Scott had mentioned, it's absolutely right. It is also petitioner's responsibility to manage their own limits. Their permit conditions are, posted and available, and they have them and are aware of them, and they have exceeded those. So this is, again, within their reasonable control, and an opportunity to submit an application could have been done well over a year ago, and this was done just a week ago. And I think a comment was made that we haven't responded yet to it. Well, again, application was submitted just a week ago. And then also wanted to kind of touch base is that, because I know we have new board members, is that, it's the district's position and understanding, being on many of these the last 5-6 years, is that for interim petitions, good cause must be found, that the findings can be met during the regular. So, typically what happens is the board goes through A through F of the findings after arguments completed, so you guys can make your deliberation. I just want to add at that point, you guys, it's potentially not my place to say, just wanted to share that information and what has typically been done in the past. Yeah, I think that concludes my comments. Oh, one last thing. I apologize. One last point I wanted to make. I do apologize. In 2020, it wasn't just a small exceedance. It was 403 hours over the limit in 2020. Significant. And then again, significant this year. That I conclude now.
Were you wanting to share the rest of your PowerPoint at this time?
That
was it. We shared the whole thing.
Thank you. Okay, so there was no surprises. That's wonderful. Okay, so noting for the record, you wanted to point out. Okay, Thank you. Do any of the members have questions for the district?
No.
Okay, so let me see. So this so I did look at the petition, and so I had a question for the district. There was discussion by the petitioner and in their written materials about this idea of fuel consumption being some sort of proxy for their permit conditions. What does the district think about this idea of fuel consumption? Yes, I recognize Dan Plotner.
Thanks, Madam Vice Chair. Dan Plotner, Program Coordinator. It is within the realm of possibility that a new or an amended permit condition regarding fuel consumption limit would be possible, but we haven't had enough time to review that with our team, and it's important to protect the public health that we have adequate time to review that.
Okay, so it's within, so let me make sure I understand. So this idea of fuel consumption being some sort of proxy or permit condition is within the realm of possibility. Obviously, it's clear it's not in the current permit, and is it in the newly submitted application that the district has?
Yes, it's part of the application, and we can't speak at this point to if it is possible, but it's under consideration.
Okay,
That's
so
all. That's all we can say at this point.
Yeah, it's being considered right now, and so it sounds like the district's position is it would be outside the scope of the hearing board's authority to substitute the expertise of the district's evaluation process for this new permit and just apply it just kind of almost arbitrarily to the old permit through a variance procedure.
Yeah, I think that's a good summary of our position. Yes.
Okay, that's all of my questions. What about any other members have questions?
Will the petitioner be, are we done with the petitioner? Will the petitioner be speaking anymore? Are we moving to a decision point?
There is a chance for the petitioner to provide rebuttal.
Before rebuttal, may I be able to ask one question?
Yes, I recognize William Jacks.
Thank you, Vice Chair. It's just if the petitioner is still in operation, that's the one question that we had, because I think they had talked about not operating. My understanding the petition, just wanted to clarify if the equipment is still in operation, still production.
Mr. Weir, you appear to be muted.
Yes, I just solved that. Two items there. Until the petition was filed with the clerk of the board, then operations had ceased. Now operations from time to time do occur and would occur under the variance, if that variance was granted. We have the ability to operate. There's material on site stockpiled, and we have the ability to crush it if the variance is granted.
So does that mean if the variance is not granted, the operations will just kind of be maximally reduced, but still proceeding in some respect if the variance is not granted, or will you have to shut down until your new petition is evaluated?
I believe, although the final decision, you'll need to ask that question of Jerry Peralt, who I believe is still on the phone line there. But certainly we can't operate in compliance with that condition. And so we choose to seek the variance rather than willfully violate a permit condition.
Okay, it looked like Jerry is still on the line and perhaps could speak to the operations of the Oceanside plant.
Yes, what would you like to know?
So the Oceanside plant, the district was asking, is the equipment still in production there?
Yes, yeah, in Oceanside, we were in production last week.
Okay.
But we're gonna cease, and if we don't get a variance, we'll just stop and continue to receive material. We just won't be able to process it.
One quick point, as mentioned in the presentation prior, is that the clock restarts January 1st, 2022. So again, these are annual, this is in violation of the annual limit. So we have talking about eight weeks only.
So in the 8 weeks remaining, this is for the district, is your understanding that that the Tom and Jerry's asphalt, this crushing could occur for a certain number of hours still? They do have some allowable legal capacity to operate, or is it the case that they have to cease if they don't get this variance?
So the district does not shut facilities down. You know, it basically, if facilities willfully for a period of time operate, there's always the possibility to entertain an abatement order. But the district does not have the authority to shut a facility down, first and foremost. And then, but also that, additional point is that, you know, the petitioner is all facilities are, regulated facilities are subject to the permit conditions and rules and regulations. So we are held by the state to ensure that enforcement is completed and also that facilities are in compliance. So by continuing to operate, they will be in violation until the rest of the year.
Okay, and if I understand, during your presentation, William Jacques, you said that that in 2020 they were somewhere in the realm of 400 hours over. In 2021, how much are they over so far?
Scott, do you have a number? I think it was 100 something, 180 something.
Actually, it was around 70 at that point when we got the information from Mr. Weir. If they had been operating since then, there would be more hours on their engine.
Okay,
so it's over 70.
So over 70 hours. So basically, it is true that they would be willfully operating in violation of their permit if they don't get this variance. So their choices are to, if they want to follow the law and their permit, they'd have to cease operations if we don't provide the variance.
That's again their choice to willfully operate or to cease operations.
Okay.
I think.
Yeah,
Yeah.
I just wanted to make sure that I understood that. And although the clock resets in January, you know, they're a small business, and so, I mean, is that does the district? What was the district's position again on the takings?
So, you know, typically when it comes to our strong argument, when this argument comes up in petitions and in this one, if a violation is in context of taking a property, you know, that's something that a facility, you know, they are responsible to be in compliance with the rules and regulations. And if they are in violation, you know, that is something that is through another process, through a violation settlement program. And from there, the Health and Safety Code outlines, which isn't a part of this process, it's a separate process, outlines the process. You have to find, identify the compliance history, identify, the size of the company, the situation, the amount of emissions, et cetera. So that is something that, again, the violation had just occurred that we issued, that we were aware of. So, and that typically is not a part of this process.
Okay.
That makes sense.
Another question then, so their application with the new proxy of fuel consumption per year being the limit, that's currently received and under review by the district. Is there any sort of sense of how long it takes the engineers to evaluate the health risk assessments of that fuel consumption limit? Is there some sort of idea of how soon that application would typically be reviewed? Because we wouldn't be asking the district to hurry up their normal plans, but how long would it normally take?
So it can vary significantly depending on the size of the company, depending on emissions, depending, like you said, if health risk assessment needs to be completed. Again, since this just was received a week ago, we don't have enough information for me to give you that stat. If this was submitted a year ago or even 6 months ago, this would not be an issue. This would a permit or this concern would have been addressed, and potentially a permit modification would have been issued already.
Okay.
Answer your question. Sorry.
But are we talking about potentially weeks for the district to be able to evaluate, or are we talking months?
Again, I think without fully evaluating the process, it can take a range, and like you said, weeks or months. Yeah.
Weeks or months. Okay.
Yeah.
Okay. Member Spencer or Member Powers, do either of you have any other follow-up questions for the district?
I do have one, and that's more about, should you come to an agreement about using fuel limits as opposed to what's currently in the permit, is that something that could be made retroactive to the date of the application and have any kind of financial or other penalty was waived at that point? Or is that something that can only be made effective the date that you actually come to the agreement?
So when a application is submitted, it becomes active essentially when the authority construct is completed. So the full engineering evaluation is done. And that's when it's become effective. So that's one part of the process. The other part of the process is the violation and potential, settlement. So that is, again, there's a lot of things to consider, the timeliness of when they submitted the information, emissions, et cetera, like I said before. So it will not be made retroactively is your question, I think, to now. It would be when the engineering evaluation is complete.
Thank you.
I do have a question here, and that is, so come January 1st, they're in compliance. They're at 0 hours, and they have a history of non-compliance for a couple of years. And Scott, you had mentioned, and obviously a notice of violation has been issued because here we are. So you've issued the notice of violation. They say their gross receipts are $11,000 a day. And so this to me is a relatively administrative issue. I'm just giving you my own perspective. And so my question is, let's say they continue to operate normal operations, even though they've been hit with an NOV. Can you project or even tell us historically what kind of a settlement penalty would they be looking at if they continue normal operations until either we get to January 1st or we reach some kind of resolution on the permit violation?
I think again, so there's a lot of factors we consider, financial impact, if there are, different challenges, the size of the business. So they can range. So for me to say this is about this amount is really, it would be inaccurate one way or another, because we needed to kind of do they haven't fully responded to the reasons why they're in violation of what occurred. From my understanding, I think the focus has been to submit the petition in response to the violation. So it's, And then also, regardless of the variance, if it's granted or denied, a violation settlement will be completed because a violation was already issued prior to a petition being submitted. So I think this, it's really, to some extent, the point is moot. Scott, you also have an additional point?
Yeah.
No, sir, I have to speak right here.
Yeah, sure. Oh, yes, sorry.
The point is not moot. I'm a small business owner in San Diego County. You
Oh,
hit
yeah.
me with a monetary settlement of $1 million, you kill my business. You hit me with a monetary settlement of $5,000, it's a slap on the wrist. I'm aware of it. I take care of it. So this, for me as a board member, is an absolutely critical question that you must answer. You must go back and you must tell me that in 3 instances over the last 3 years, when we had an administrative, what I'm calling an administrative violation, just tell me the numbers. What was the settlement monetary amount? Because I'm looking at his business. He's telling me $11,000 a day. So your answer, if it's $1 million, we kill his business. If it's $5,000 or $10,000, I see it as like not paying your auto registration. You didn't pay your auto registration, you're out on the street, you get CHP pulls you over, you pay $100, you pay $200. It's annoying, but it doesn't kill your business. It doesn't prevent you from driving. So without me knowing that, it is absolutely not moot. I mean, it's the whole ballgame in terms of the decision that I would make now.
I understand and respect your comment. And when I said moot is you're right. It's not insignificant. It's not unimportant. It's very much important. My point is that, if this was identified prior and a variance was granted, it would cover a facility. So a violation and settlement penalty would not have occurred. I'm saying since the violation occurred prior, that's the situation. So, but the response to your question is that yes, historically administrative versus violations are significantly less. In order to give you a dollar amount or a number, we'd have to do that full analysis for the violation settlement program. So I don't want to say this is this dollar amount, but it is significantly less an administrative type violation.
Well, I tell you what, I mean, this is not helping. I need you. You've worked at the district for years. You've dealt with many of these situations. Give me a range. You don't have to take no responsibility. You have gone to monetary settlements for administrative actions. What is the range?
So again, we consider financial burden. We are held to the health and safety code. If a facility is impacted by COVID, we made it very clear. We're also considerate. We're talking about millions of dollars, nowhere near. So I mean, this is typical administrative violations can range from a few hundred to some lower range thousand. I'm not saying that this is here because we haven't done the full evaluation.
No, that's exactly what I.
Typical general administrative type violations, but that may not be completely accurate because we have to do it.
No, and I understand that completely. I'm not trying to put you against the wall. You have given me exactly the information I needed. That's all I need.
Can I say it's also it's important to say it's a mutual settlement process.
Thank you.
The violator has to agree to the settlement amount.
Mhm.
Okay.
Yeah, and financial burden considers small businesses as well. That's a big part of what we look at. We don't, no one size fit all. It's small business, large business. The idea is to deter future violations.
This is great information. This is background because, again, as a small business owner, if I don't have an idea that, you could potentially kill my business, then I can't make the call to vote against this variance. But with the information you've given me, I just feel much more equipped to make an informed decision. Thank you.
Understood. Thank you for the question.
Yes.
Yes, and I believe kind of what this goes to, and this is a very excellent issue that Member Powers has brought up, is I know that the district's position is that it was not reasonable. It was not beyond their reasonable control. But I know that the petitioner has petitioned that it was beyond the reasonable control. So I guess what I would love to hear, and so maybe that's why you thought these questions on takings were moot or mentioned this issue of moot, but really, that's what we're here to decide. And so it's not moot yet unless we decide it was beyond their reasonable control. So I guess what I would love to hear more from the petitioner on rebuttal is could you perhaps give a little more meat or detail on why this was beyond your reasonable control? Like why, what were the impacts that COVID closures made during 2020 that caused this overage of like 400 hours? It sounds like the Fallbrook facility was closed. Were you trying to keep up the same level of business at one facility, or at least keep things going for the business enough when you couldn't operate two facilities? Like would you have been normally able to without COVID? What would have been the situation without COVID happening? I guess that's what I want to know. How did COVID really impact things versus what would have happened without COVID happening in 2020?
Madam Vice Chair. Oh, Jerry can start. I'll conclude. Thank you.
Thank you.
Jerry, please go ahead.
Oh, okay. In 2020, the first part of the year, we started to some of our employees were starting to get sick, so everybody has their own position, so we were trying to space everybody out and keep everybody separated and as much as we could, and no one was allowed in the office, just myself and one of the other girls, and we just tried to keep it at hand. And the machine hours, I don't know how that got away from me. The engine hours, the machine itself, I just can't tell you. The Oceanside, we're open 6 days a week, and I don't know what else to say. I'm beyond words. I'm a rule follower. I've been a rule follower my whole life, and I was the one asleep at the switch. So I don't know. I just can't say.
Okay, and Paul, did you have anything to add?
Just 2 quick points. The first one, the petitioner really does have to admit that a mistake was made about the hours. That's just beyond dispute. What we're trying to do is avoid having to close the business for November and December until we reach the end of that calendar year. We really are trying then to mitigate as much as possible so that we can keep those employees working through the end of the year. And to my knowledge, there's no other way that we can do this and remain in compliance with the rules and regulations of the district. That's what the variance procedure is for. If the hearing board can find that this would be an unreasonable taking or closing of the business. We're on it. And we will do our best, but their goal is to remain in compliance with the standards, recognizing that they blew it. And they can accept those penalties, but they do have a small business to run and employees to continue to work through the end of the year. That's that's the reason for this variance. It's not to create additional impacts to the community. And that, unless you have another question, that would be my summary.
Thank you. And as I understand it, Jerry Peralt is currently sick with COVID and has been for the last week, at least. And so there's even current COVID impacts to the business because, I mean, that's kind of a big deal, right?
Well, and certainly the amount of materials that could have been received in both years were affected by COVID, even though they are a essential business. You know, getting the trucking in, getting materials back off-site to needed customers, all that has been severely curtailed during the period of COVID.
Okay. Do other members have additional questions?
No additional questions, a comment, but no questions.
Okay, is your comment directed to either the district or the petitioner?
No, it would be for us as we get ready to make a decision.
Yeah, perhaps we should, if there's no other testimony that is planned to be given by either the district or the petitioner, what I think might be good to do is allow the hearing board time to deliberate and discuss the issues.
I have one additional comment. It's just a follow-up from my last comment about the time frame of the variance. If granted, typically it's when the start date is when the time from the hearing moving forward. So that was a comment to my previous statement that the violation is in the past. It was issued, I think it was in late September, if I have that right, Scott. So a violation had already occurred, and that settlement or a penalty related to that would not be under this time frame for this variance. That was what I was trying to say prior. Does that make?
Okay,
Yeah.
so in other words, if I understand you, there is an NOV on the record. There will be a penalty regardless. But certainly if the variance is granted, would you say that if they continue operating under the variance, obviously they won't be piling on at more NOVs and penalties?
Yeah, the point of the variance would be to cover during that variance period, so there would be no violation.
Okay. Yes. So, but either way, there is the one NOV and there is the one penalty coming. Okay.
Yeah, because since the penalty was discussed, I just kind of want to be clear, transparent.
Very good.
And Madam Vice Chair,
Yes.
that was the most excellent summary by the Air District too, and petitioner is aware and also acknowledges, that again, that mistake was made. There will be a penalty for that. Now we're trying to go forward without creating additional violations. Thank you.
Thank you. Okay, so I'd like to close the testimonial period and presentation of these matters, and allow the hearing board members to give their comments and deliberations as we discuss the potential findings. And so I recognize Member Powers. I believe you had comments directed towards that.
Yes, I'm very sympathetic to Mr. Peralt and to his small business. But I also see this as a warning was received in the middle of June 2020. Plenty of time to take action. The action didn't happen, resulted in an NOV. They're continuing to operate. The district has indicated that the penalty will be mutually agreeable, not a draconian imposition. And I'm also leery of having our board agree to new permit terms that really haven't been fully evaluated. So I would just say that I would deny the variance, period.
Okay, thank you for your comments. Member Gonzalez or Member Spencer, any thoughts?
So I have a few. To start, we certainly want to be cognizant that we don't want to place any kind of undue burden, undue taking of any small business, and we certainly want to do what we can to keep people employed. But at the same time, business decisions that were made for whatever reason, or mistakes that might have been made for whatever reason, aren't really the hearing board's thing to correct. And so when you get into just kind of running down the checklist of the criteria of what to do, was the first thing is was it beyond the reasonable control? Now, certainly the COVID pandemic was not something that was anticipated at the time that this permit was issued. But that said, there have been 18 months since the pandemic began, so there has been time to adapt. There was a pretty significant, I believe, about 40% exceeding of the allowable hours last year, and then a very similar trend happening this year. And just now, after the notice of violation, we're hearing about it. So, with the burden of proof being on the petitioner, I have a hard time seeing that it is beyond their reasonable control. And in terms of one of the item, I believe it's item E, about reducing excessive pollutants, the petitioner has said that they would be within what's recommended, or within what's allowable on kind of a ongoing, per day basis. But, according to the permit, what they should be emitting right now is 0. And obviously something is higher than 0. And if I were a resident in that area, or using the sports complex in that area, or had a child attending a school in that area, I might take issue with that. So for a lot of those reasons, I'm inclined to vote to deny the variance.
Okay, Member Gonzalez, do you have thoughts to share?
Yes, ma'am. I go along with the reasoning and the information that was provided by the petitioner. It does seem that they just completely neglected to address what was being requested by the board. So I follow along with the other two members with their decision to deny the variance.
Okay. So I have a question for Emily Helms.
How can I help?
Yes. It's looking like the interim variance is likely to be denied today. Does that remove from the calendar the regular variance hearing?
No, it does not.
Okay, so possibly we would be back here again in November talking about the Peralt's business and situation, and so yeah, so it's going to come before us again.
Yes. So the point of the interim variance is to bridge the gap, if you will,
Yes.
between this point and the regular variance. The findings for an interim variance are good cause. Usually you take into consideration whether or not the petitioner is likely to make the findings required by a regular variance. So yes, the regular, unless the petitioner were to withdraw, the regular variance stays on calendar, and then we would go through, and the board would be required to make each of the findings.
All right. Okay. Thank you for clarifying that.
Of course.
As chair, it's not my job to guide or direct the board. I believe we've heard everything today. It looks like we have deliberated. I feel for the small business. I am aware that their testimony was that their Fallbrook operation has been closed. So they're already, as a business, operating at 50, at a lower capacity overall for the region. However, when we're looking at emissions and air quality, these permits are designed to protect, the neighborhoods as well as the region. And so, I mean, it's unfortunate, but I don't. It's hard for me to diverge from the deliberation, from the comments made by the other members, to try to think, oh, actual neglect and ignorance of their records is somehow beyond their reasonable control. So I think I'm going to agree that we cannot find that that circumstances were beyond the reasonable control of petitioners, and therefore that threshold question of good cause, we can't find that at this time today that the regular variance would likely to be granted, because because the daily operations, the logs, the knowledge of of whether an engine is running or not, that's something that is within the control of a business. So I believe, is there a motion? There a motion by any of the hearing board members regarding this petition? Is there a motion to approve or deny?
I would motion to deny the interim variance. If someone could help me with the number of that interim variance.
Okay, the petition number is 4523. So I have a motion on the table by member Powers to deny petition 4523's interim variance. Okay, and do I have a second?
I'll second.
Okay, and what would you say, Mr. Powers, that the denial is based on?
The denial is based on the petitioner not demonstrating reasons beyond or causes beyond their reasonable control for being out of compliance with their permit.
Okay, thank you very much. I'll restate this. There's a motion by member Powers, seconded by member Spencer, to deny petition 4523's request for an interim variance based on petitioner's failure to demonstrate that causes beyond their reasonable control. Madam Clerk, will you please call the roll?
Yes, member Gonzalez,
Yes.
member Powers,
Yes.
member Schlick,
Abstain.
member Spencer.
Yes.
Okay, that vote passes with 3 members being present, voting yes, and member Schlick abstaining from voting. So this means that petition 4523's interim variance was denied based on petitioner failure to demonstrate causes beyond reasonable control. So just for clarification, I just want to make sure. So we are going to reconvene on November 18th to hear the regular variance portion of this, unless the petitioner withdraws that regular variance. Is that correct?
Yes.
Okay, thank you. I will note that for the record.
Thank you to everyone for your participation today. Is there anything further? Madam Clerk? You're muted.
Nope, there is no further business on the agenda today. Thank you all for attending.
Okay, I'd like to call this meeting adjourned, and we will, what is the date of the next meeting, Madam Clerk?
The date of the next meeting is Thursday, November 18th. And the meeting will start at 9 a.m. And as voted on earlier in the meeting, we will continue these meetings via Zoom. Also on November 18th, we will need to vote again on that resolution to continue the virtual meetings. So that'll be added to the agenda.
As well as adoption of these minutes for today. Thank you so
Yes.
much.
Okay, thank you.
Okay, so we'll see all the members, all the hearing board members back again, and any members of the public and any other business that comes before us on Thursday, November 18th. Thank you all for serving today. And for
Thank
your-
you.
Thank you.
Thank you, Madam Co-Chair.
Thank you all.